The time is ticking away, and although we have competition with lunch, I think I'd like to begin straight away by introducing the panel and saying a little bit about what we're going to talk about. We have, going along the row, we have Dr. Dalia Fahmy, who is the director of the International Relations and Diplomacy Program at Long Island University, Dominic Grieve, who's a former Attorney General of the United Kingdom and chairman of the Intelligence and Security Committee in the House of Parliament. And then we have Bart Katerubi, who was Chief Justice of Uganda, and before that, an Attorney General and Minister for Justice. And as you can tell, therefore, from the panel, we are going to talk about law. Now, during the course of this morning's introduction, a lot was said about the importance of the rule of law and of the way in which it was important to hold people to account. And one always must recall that whenever international conflicts break out, almost everyone wishes to justify what they do by reference to legal principles. And it is, I think, particularly important to recall that the rule of law internationally is as important as everyone acknowledges to be the case, the rule of law domestically. So I was going to turn and ask the panel some questions, beginning generally with the rule of law, turning to territorial disputes, and then expanding it into areas where there is much current interest, namely incursions into another territory and holding people to account for breaches of humanitarian law. But let us begin with a very general question, and I was going to ask Dr. Fahmy to begin this by asking her, why is it so important that states observe the rule of law?
So international law, or the rule of law in the international system, is fundamental to international peace and security, but also to achieving economic development and security, and also the sanctity of human life. We know, as we just referenced, that laws within states govern everyday principles that people live by. But laws between states in an anarchic system don't. And so it's been the international law of norms that has been able to govern the relations between states. And since there isn't the outside implementation, it is the voluntary adherence to international law that becomes important for us to focus on. As we heard this morning, when international law is not applicable to everyone, it becomes undermined to everyone. Or the possibility of it being undermined for everyone. So the role of international law today is critical, and critical for us to understand how it's going to play out in future conflict.
Well, thank you very much for that general introduction. Now can I turn to something more specific? And the primary matter which we're going to address at first, which is territorial disputes. Now, territorial disputes are often one of the primary causes of armed conflict. But history shows that a number of such disputes can be settled by peaceful means, such as arbitration or mediation, or before the International Court of Justice. And I was going to ask Dominic Grieve, first of all, if he could say what are the sort of factors which enable some disputes to be settled by peaceful means, and what are the factors that primarily cause peaceful resolution to fail?
Thank you, and it's a great pleasure to be here at this forum. It seems to me that the first and most basic criteria, and echoing what's just been said, is are the countries concerned signed up to an international rules-based system for dispute resolution? And there's obviously a big variability about this. And taking the United Kingdom, I once asked the Foreign Office, how many treaties is the United Kingdom signed up to? And the answer came back after a certain amount of hesitation, well, we think 14,000. Which probably makes us the greatest treaty-making power in world history, with 800 at least having arbitral mechanisms for dispute resolution. And of course, in some cases, like UNCLOS, or signing up to the International Court of Justice, the implication is there at the outset that if there is a dispute, you will seek an arbitral route to resolving it. Whereas for some countries, they may really have avoided as much as possible signing up to such mechanisms. So the predisposition of a state to doing it is clearly very important. The second thing and one has to accept this in the world of politics, is how central is it to that state's identity or well-being, or indeed its politics? A lot of the recent successful arbitrations, as one only has to look at the list, often concern international maritime disputes, so they're not necessarily the land territory of the country concerned, or they may concern quite peripheral areas of sovereign territory which have been uncharted or have not been properly defined. So on the whole, those may help. And then you've got the regional environment. Does the region support this type of dispute resolution, or does it look at it as a sort of form of weakness if you're prepared to engage in it? So if you get the right atmosphere, I think you can, in many cases, get the outcome leading towards a dispute resolution. And of course, one's got also to accept that not only have you got to have the dispute resolved by arbitration, but then people have got to accept it. And I'm afraid there are quite a few examples around of countries which have gone through arbitration and then resile from its consequences. Argentina and Chile over the Beagle Channel until the Pope intervened. Initially, the first arbitral award was effectively objected to by Argentina. Other examples, one can think of other examples as well. And what's happening at the moment between Venezuela and Guyana is suggestive of an arbitral process where nearly 100 years after, more than 100 years after the original arbitration, a state is now apparently resiling from an arbitral award about a boundary that was made in 1899 and which they accepted at the time. So one has to look at the reality of it, but I'm absolutely convinced that the first thing is people have to understand the virtue of the international rules-based system and therefore be willing to engage with it. Secondly, that their peer group, their local countries are supportive of what is going to be done and that they have a reputational stake in it. And finally, and I think this does make a big difference, that the countries are mature in their ability to sell their own electorates or their own people as to why it's advantageous to resolve a dispute in this way.
Thank you very much, Dominic. I wanted to pursue further this question in relation to territorial disputes, and by drawing on your own experience in Africa, are you able to tell us how legal principles can be helpful in the resolution of long-standing disputes in relation to claims to a particular area of territory, particularly either through arbitration, through mediation, or before the International Court of Justice?
Well, thank you. The question is, if you didn't apply principles of international law in resolving a territorial dispute as a state, what would you apply? Because disputes have arisen. And for us in Africa, most of our territories for our countries were the boundaries as left by the colonial masters, boundaries that were made in Berlin in 1848. And it was agreed as a principle right from the beginning that the colonial boundaries will remain. These will be the boundaries of our new states. We very quickly, early on, signed on to the United Nations Charter, to the Statute of the International Court of Justice, and other regional bodies. So by doing that, we accepted first the inviolability of state boundaries, the respectability for states, the equality of states. So if any dispute arises, it follows that it has to be resolved in accordance with established international law. If you didn't do that, then you'd probably have been the law of the jungle. In Uganda in 1978, our then President Idi Amin claimed part of the territory of Tanzania, what is called the Kagera Salient, and sent in troops. And the reaction of the Tanzanians was swift. The Organization of African Unity tried to mediate. It was too late, and Uganda and Tanzania went to a hot war. We had over 40,000 Tanzanian troops in Uganda, which led to the overthrow of the government at the time and imposition of another government. That's how bad it can be. But there have been other disputes where the states quickly recognized that the only way to resolve their dispute was through either mediation, to accept a regional intervention, I was involved in 1990 or 91 in the mediation between Senegal and Mauritania. There was a big boundary dispute, and it was leading to hot hostilities. And the Organization of African Unity sent in a delegation that met President Diouf and the President of Mauritania, and the situation was de-escalated. So I have seen a number of disputes that have arisen in Africa, and the first call has been for the parties themselves to try and negotiate and diplomatically resolve, call in another mediator, or bring in regional organizations. This is what has happened in Congo. This is what has happened between Namibia and Botswana. So it is something that we have to do. Apply international principles, or else what do you do? Thank you.
Well, thank you all very much. And then can I take you to a further question in relation to territorial disputes? Now, it's unlikely in the foreseeable future that we're going to be able to, that states would be prepared to accept compulsory jurisdiction. But what can be done to make peaceful resolution of territorial disputes more attractive and to strengthen the will of states to submit disputes to peaceable resolution? Dr. Farman, do you want to try that first?
When we look at the reasons why wars happen initially over territory and over sovereignty. And in the post-Cold War era, we moved away from conflict over territory to conflict over the sanctity of human life. And it begs the question of several things, of what is the importance of us understanding the criticalness of that shift, and what does it mean for long-term understandings of the role of the international community in settling disputes, especially those that have large humanitarian consequences. We know that the range of intervention usually deals with the range of the cost of war. States are more likely to negotiate or accept mediation if it's within the range of the cost of war if they were to go to war. But we have to ask ourselves an even deeper question. Which states are forced into these mediation moments? It's usually mid-level states in the international system or poorer states. We don't see this at the highest levels. And so it begs the question of where is this going to go into the future? In the early 1990s in Bosnia and East Timor and in Somalia, we saw intervention or the kind of bringing parties together in a forcible way because of the level of humanitarian crisis. But that weaned at the end of the 1990s. And today we are seeing a system that is less likely to intervene in moments of not just humanitarian crisis, but in genocide. My own, in the United States, late Secretary of State late Secretary of State Madeleine Albright, with regards to Rwanda, had absolutely no problem saying that the US had no strategic interest in Rwanda. And so basically the massacre could continue. And it wasn't until much later that she acknowledged that it was a genocide. But after what? And so the international system has to adhere to the international law principles by accepting the norms for everyone equally.
Well, thank you very much. Can I ask Dominic Grieve again to comment on that from a practical perspective before I turn to a slightly different question to Bart Kataruby?
I certainly agree with that. I'm perhaps a little less pessimistic on one or two points. I think of the Northern Ireland peace process, it's very easy to forget that it did actually have a territorial basis to it. It was a dispute. Ultimately, it's over identity, living in a territory, but in a territory that was claimed by the Republic of Ireland, but was part of the United Kingdom. And the Americans never wanted to get involved because they considered they had a very important strategic partnership with the UK. So what prompted it was actually the UK, probably through the process of European engagement and a desire to improve its relations with the Republic of Ireland, actually asking the United States to intervene and see if it could break the logjam of the discussions that took place. So in a way, this was something which wasn't arbitrated. This was a process which was voluntarily embarked on by the parties and led to an effective resolution of the territorial aspects of the dispute through a referendum in Ireland, which removed the claim but also preserved the right of self-determination to the inhabitants. So you can get examples which go away from what I would call straight arbitration. But I agree that the problem is that it is the arbitration of weak countries, and it comes across as that. So how does one get away from that? Well, one only gets away from that when strong countries are prepared to accept jurisdiction. And yes, there is a long history, particularly with the United States, of the United States not being very accepting of international jurisdiction, which I regret. The United Kingdom, in contrast, actually, on the whole, has been a great promoter. That's not to say it's always been perfect in its adherence, and there are some recent examples of which I think are open to criticism. But the nub of it is that the UK has sought to promote this. And certainly when I was Attorney General, one of the central roles I had was making sure that the United Kingdom observed its international legal obligations and worked within them to promote dispute resolution. And I think that lies at the core of what's needed if one is to take this forward, because otherwise, I agree, smaller countries say, why should we sign up to a process which you, the bigger countries, impose on us? We've also seen it with the International Criminal Court, where the criticism is that if you behave badly in a small state, you may end up in prison in the Netherlands, but if you're from a big state, you are untouchable.
Yeah. Now, can I move the discussion about territorial disputes on a little bit by asking you, Barker Ruby, the question which sometimes occurs of one state intervening to help in a dispute in another state. Do you think the principles for intervention in such a state are reasonably clear, or should more be done to clarify them?
I think at all times there must be clarity as to when another country should intervene in another country. It all depends on the nature of the dispute. It all depends on whether the other country has invited this other country to come in, or it is unilaterally coming into it. What we are beginning to see now is interventions where there has been armed confrontation and one country or the other moves in ostensibly to the other, but sometimes for their own reasons. And this we have seen in the Democratic Republic of Congo, where there is a war going on even now, where the intervention of my own country eventually led to us being taken to the International Court of Justice, where the court has just given a decision against us. But nonetheless, that was a war that drew in 6 African countries. So it became a big regional war. So when you want to intervene in another country, first of all, what is the nature of the dispute? Are you doing it unilaterally or the invitation of the host country? Is it supported by the regional countries involved in the West African extent, for example, whether it is ECOWAS, whether it's the East African Community, whether it is SADC? If it is just unilateral, it will invite in, what we have seen, it will invite in others. When Uganda originally went to Congo, it was ostensibly on the invitation of the Congolese government. It then drew in Rwanda. Before we knew it, we had Zambia, we had Zimbabwe, we had Angola. It became a big regional war. So to go in unilaterally is fraught with danger. I think it should be negotiated, and known principles are applied as to when a country may go in or go out of another country.
Well, thank you very much for that observation, because one can see how how disputes of this kind can build into something much larger. Now, another problem with international law, or perceived problem, is that states feel they're entitled to invade another country, go into another country, because they say they're militants in another country who are threatening them. And I wanted to ask each of you whether you think the principles in relation to that are sufficiently clear by reference to the way in which it's developed in the past. And can I begin with you, Dominic?
This raises some very big issues. Clearly, under the UN Charter, you have a right to self-defense. So if you have a boundary which is internationally recognized, but it's being violated by terrorist groups, for example, coming across from another state, and the other state is not controlling those or seeking to do anything about dealing with them, under your right of self-defense under the UN Charter, you may have a right to cross the border in hot pursuit or otherwise. There's an example of this, of course, with the Turks and northern Kurdistan is one example. And you will claim a right under the UN Charter to do that, a right of self-defense. Outside of that, it's very difficult to think there's any justification unless it is as a result of either a UN resolution of the Security Council, an all-means resolution. That's, I suppose, what happened in Libya with the Libyan intervention. Or alternatively, some countries, including the United Kingdom, recognize a right of humanitarian necessity of intervening in another state if they consider that the behavior of that state is so bad towards its own citizens that it would justify you intervening in this fashion in order to specifically not, and it's very important, this as a distinction, not to topple the regime, but to stop whatever the activity is which is taking place. But I have to say, I think the history of the last few decades is that armed interventions into other people's sovereign territory always comes at very considerable risks. And it often leads to uncontrollable escalations and problems for the countries doing it, even if they may have had legitimate intentions when they started it. I'm not sure what the answer is to this, but it's a difficult environment. And one of the key issues is that whatever your intervention is, your standards of behavior have got to meet international humanitarian law standards. And in many cases, the country in which you may be intervening may not meet those standards itself.
I'll come back to international humanitarian law in a moment, but can we keep the question to the initial one that I asked? Can I ask you, Barker, your view on this point, and then I'll go to Dr. Fahmy.
Yes. Intervention in another country because you have suffered an attack by armed groups from the territory of that other country is something that we are seeing very often in East Africa now. The initial reason for Uganda, for example, going to Congo was because there is an armed group which is associated with ISIS that has been attacking Uganda. And there had been a horrible attack where that group from Congo came and attacked a school and killed 80 students in their dormitories. Now, one would say on the face of it, why isn't Uganda entitled to go into Congo in self-defense, which is exactly what we did. But the question that arises now in international law is, even if you've been attacked and you go in pursuit of the rebels that have attacked you, how far do you go? How much can you do on the territory of another country? And especially if the other country doesn't show that they were arming and supporting the rebels. I remember that case when it came up. I was the Attorney General, and the question was, if you've been attacked, why do you have to go beyond the border? Why do you go 500 miles inside? And the answer is, but if the supply lines stretch 500 miles, why shouldn't I go 500 miles? And I think this is a question which is also arising in the Middle East now. How far do you go in self-defense and in pursuit of the people that attacked you? How much damage can you inflict? So there is a correlation between now applying principles of international law and at some point applying international humanitarian law. And this has been the decision now recently in the International Court of Justice, that once you are there and you become the occupying power, then you must apply principles of international law in terms of protecting civilians and other vulnerable groups. So this has happened. How far do you go? What do you do there? And for how long do you stay there? Do you become an occupying power? You go in and kill a few rebels and you come back. And then they come again. And indeed, actually in Uganda, only last month, that same group crossed again into Uganda and killed 40 students, 40 girl students in a dormitory. So this is going on. And right now we have a part of the Uganda army working jointly with Congo, this time jointly with Congo, to fight the rebels. But when you go unilaterally, you may get up there and find it difficult to come out.
It's interesting that we are able to discuss these other examples before we come to what is quite a difficult current problem that's been the subject of so much discussion this morning. But before we move on to international humanitarian law, I wanted to ask Dr. Farming, what do you think are the principles that are applicable to this question of armed intervention in these circumstances?
So in just war theory, we have jus ad bellum, which is governed by 3 principles. Is this a last resort? Has every aspect of diplomacy been met? Is it proportional? Is it going to cause more harm than if it was left alone? And what is the long-term consequence going to be? If we look at this in terms of today and what we heard this morning, the eradication of 10 to 30,000 Hamas fighters at the cost of what? The destruction of all of Gaza, the displacement of 1.7 million people, the destruction of its infrastructure, that there is no food, electricity, water. And we have governing principles of proportionality. And so we have to ask ourselves, what is missing here? In the context of terrorism, why is there no internationally agreed upon definition of terrorism? In the United States, if we go by the CIA definition, which is politically motivated violence targeting non-combatants, then how many states are guilty of that today? And so the bigger question is this notion of proportionality. Is it adhered to and how is it understood? And if it's not just going to the border, but 500 meters in for supply lines, what does it end? And then how many people suffer as a consequence? Conflict is protracted. The end of that is definitely the beginning of the next one. So how do we put mitigators to prevent this?
Now, I want to move slightly on to look at international humanitarian law and then come back to a more general question in relation to the enforcement of international law. Otherwise, we can get very depressed as to the future. But can I ask you about international humanitarian law first? Are the standards fairly generally accepted? And then I want to go on and ask each of you about how do you hold people to account? But Dr. Farming, can I take you first on the standards of international humanitarian law? Is there really much dispute about those these days?
The UN Charter that we're going to, the human rights aspect that we're going to celebrate 75 years of next year, there's no disagreement on what the protection of humanity means. There is disagreement on when we protect it, whose humanity is protected, and at what cost. And so until we have those deeper conversations, we can talk about agreed upon definitions, but we don't talk about agreed upon mechanisms of implementation. We don't talk about agreed upon definitions of what does it look like to hold states accountable for their behavior. And until we are comfortable having those uncomfortable conversations, yes, of course there's agreed upon humanitarian definitions of human rights law, but are they adhered to? And are they adhered to universally?
Can I ask you then next, Don Grieve, the question as to holding, A, to the standards, and B, in holding people to account. Are we making any progress in this respect?
Well, we've certainly been trying to make progress because there are examples of people being brought in front of the International Criminal Court for violating humanitarian norms and humanitarian law in situations of combat. There was an Afghan war leader who was taken to the International Criminal Court, and of course we got the examples that come out of Bosnia and Serbia, of I think the key ones. And it's right that there are, I think the principles, I agree, are very well established, necessity and proportionality for a legitimate aim. If the aim isn't legitimate, then it doesn't matter what the proportionality may be, it's unlawful. But on the assumption that it is for a legitimate aim, then the question as to how you judge necessity and proportionality is, I think, inevitably quite difficult. How much collateral damage can be accepted? Sort of problem which, when I was Attorney General, I had to grapple with. what is the purpose of the intervention in international law, coming back to what we were talking about, and is it being exceeded? Another example. So I think we may be mistaken in hoping that we can achieve perfection in all this, because states will argue, and I don't think unreasonably, that in a situation of armed conflict, if in fact the armed conflict was initiated properly on their part because it was necessary, that every minute detail of what happens can be crawled over, because if you do that, then you come back to the very good argument that on the whole it would be much better to avoid violence in human affairs completely. But that said, I do think there is a role, because there are simply egregious examples of disproportionality that come in. And clearly, in today's conference and opening it, there is a very strong sense that whatever the origin of the current conflict in Gaza, the Israeli actions are disproportionate to even the horror that was unleashed against them. And that's clearly very strongly felt. And I have to say, as an outsider looking in, it's very easy to see why that argument is being made. But how we resolve that, and the other thing we perhaps also need to keep in mind in the international law sphere, is that we don't have a supreme world tribunal to deal with these problems. So the argument always comes back that there is political influence at play, that it is the play between the strong and the weak. And I think one has to allow for some latitude in that as well. And one has to try to deal with the egregious examples of disproportionality and lack of necessity, whilst being aware that in the flawed environment we live in, you're not going to be able to lay down totally hard and fast rules.
Bart, can I ask you the same question, drawing again on your own experience? To what extent do you think people are now beginning to be held to account for breaching international humanitarian law?
Well, as the last speaker has observed, many of our countries, including mine, have signed up to, for example, the Rome Statute, and we have had Ugandans who acted very, very atrociously in northern Uganda during the time when we had the Lord's Resistance Army. One of those leaders is now at the International Court of Justice. We ourselves participated fully in the Rome Statute so that even our own people who act with impunity can still be taken out there. But I think the problem is, if those principles are not applied across the board with equality, with regard to whoever commits humanitarian crimes anywhere, if they are not subjected to the same rules, then you will have people saying, why bother? And indeed, you had many African heads of state coming up and say, it looks the International Criminal Court is for trying African leaders, and some of them, including my own, trying to pull out. Yet the very reasons which had taken us there were to prevent this type of thing from happening. It's only until when they themselves get caught. We have to apply international law across the board. And then, with time, each one of our countries, each one of our leaders, will see that it pays to resolve disputes peacefully. If we can prevent a hot war, if we can prevent having to go in, and then command and control, because your troops get into a country and they commit atrocities, and you must still be held accountable if it can be shown that you are in control. And this is what is part of the problem in Congo. So the nature of the dispute again comes in. At the independence, for example, in Kenya, there was a region of Kenya, northeastern region, which is inhabited by indigenous Somali people. Then there was the Somali state, which had been created. Now, there were armed groups within that region who wanted to join Somalia, and they were supported by the new government in Somalia. And there was war in northeastern Kenya for about 5 years, until around 1968, when the Somali government and the Kenya government sat down and agreed to establish relations. So in terms of people committing atrocities and getting away with them, we have to stick together, that there must be internationally recognized norms, even if it is the International Criminal Court, if it is regional courts, that must be applied across the board. But I think the starting point should be, can we prevent going that far? And that brings us to how countries can go for mediation, for arbitration, for reference to regional bodies or to the International Court of Justice to have the disputes resolved peacefully. Because when it goes into a hot war, from experience we have seen, it goes beyond what we had envisaged. I think when Uganda went into Congo initially, which was to pursue the rebels that had attacked us, we didn't realize we were going in for a war that brings us into war with Rwanda on the territory of Congo, and so many thousands of people would die, and to have the International Court of Justice now order reparations running at over $300 billion against the state of Uganda. So this is what can go wrong.
Well, thank you all very much. Before I ask one or two more questions, I wanted to throw it open to the floor to see if anyone wanted to ask a question which might bring up a degree of disagreement. But before, what's interesting is that we're all lawyers, and we have basically a very, very similar attitude, and I hope an attitude of hope. But there was a question here. Yes?
Well, thank you very much, sir. Would have a question for my learned friend, the Honorable Dominic Grieve. See, I think we could all agree that international humanitarian law is quite inefficient in general, and international business law is indeed efficient. So my question is very specific. Don't you think that we should push and lobby for a reform of exit convention and bilateral investment treaties in order for countries potentially to denounce or these investment treaties in case of USCO games breach or humanitarian law breaches committed by one country? So say we have the issue with Ukraine, Russia, Israel, Palestine, the US, or whatever. Say with the Israeli-Palestinian situation, we know Israel has signed the exit convention. So if we consider that there is a humanitarian breach on the side of Israel, companies or other states may have a ground under bilateral investment treaties if they are reformed, and that could be applicable to all of the other countries.
Sorry to stop you, but we need the answer.
I understand the point, which is really that one will use the workings of the commercial courts in order to put leverage on the behavior of states over humanitarian matters. And I can see that that is a possibility, but it's going to require countries to sign up to it. But I can see that that is a potential way forward. I mean, it's worth bearing in mind that I'd like to think that the most mature states on international humanitarian law enforce their own standards. It is rather important. One point we didn't really make. British troops in Iraq, some of them misbehaved, and I hope that that was dealt with properly within the UK legal system. And as we know, I'm afraid that if you send armed men into doing anything, it will be a miracle if their behavior is always perfect. But leaving that to one side, to answer your question, I can see that, but it would need to set up a completely new international architecture. And you don't have to look very far to see that countries, we have sanctions regimes which get violated serially by countries which wish to do it. So I'm not very optimistic that this is going to lead to an effective outcome at present.
Thank you very much indeed. Are there any further questions from the floor? No.
I think the lady there put her hand up. Did I? Perhaps not. Perhaps I wasn't seeing properly.
No, I don't.
So it was my mistake.
Okay, but can I go back then to ask you this question? An awful lot was said in the opening session this morning as justice being international law being seen as something that the powerful use when they want to use it, and they use it against the weak. And that is contrary to everyone's fundamental understanding of justice, because if whatever form of lawyer you are in any country in the world, you always regard laws protecting the weak against the powerful. What could be done, either looking at territorial disputes or international humanitarian law, to get over to people the need for justice to be understood in that way? And can I ask you first, Bart, about this?
Well, as of now, we are looking at the world after the Second World War, when the world got together to form the United Nations and have a United Nations Charter with principles that were supposed to apply across the board. We are now seeing the United Nations Charter in practice. Is it being applied across the board? If it is not being applied across the board, in terms of the equality of states, in terms of observance of international law, in terms of not being able to infringe on the rights of others, if it is being applied separately from one group of countries to the other, big or small, then maybe it is time to go back to the drawing board and say, what is the nature of international law today? Because the principle of equality of states as member states of the United Nations, if we can say a small country has no voice, a big country can invade a small country and get away with it, and especially the duty of the big five, the people with the veto, do you use your veto in order to promote world peace or to protect your interest? Then what happens to those countries, members of the UN, who don't have a veto and they have interests that may collide with yours? How will you ever apply the principle of equality of states? So from what we are seeing, and indeed, even when negotiations were going on for the Rome Statute for the establishment of the International Criminal Court, there were countries that deliberately refused to join up to the International Criminal Court. And the argument was, we have our own systems which can deal with our own people, soldiers, if they misbehave outside. But if a Ugandan soldier is serving in Afghanistan and misbehaves alongside an American soldier, and why would you say the Ugandan soldier can be taken to International Criminal Court, but you may not take the colleague with whom they committed the offense? These are issues which may appear small, but I think it is reaching a situation where we need to take a fresh look at the principles of international law as agreed. If tomorrow, you saw now Guyana and Venezuela, over that region they are fighting over, isn't it important that the principles of international law should apply as they applied at the time of their original agreement, without having to say because you are now on this supported by this side or the other, so that even small Guyana can have their rights recognized under international law? I think we are getting into a situation where people fear the United Nations is for the powerful. Me as a small country, I can only go to the United Nations for relief when I am killed, when my property is destroyed. We saw what happened in Rwanda. I think somebody made reference to it. To have 1 million people killed in 3 months, 3 months 1 million people were killed, and the United Nations was betting whether what was happening in Rwanda was genocide or not. This happened. If you read a book by the Canadian general who was commanding the UN forces in Rwanda, General Dallaire, he said it was an unmitigated disaster. People were killed, up to 1 million people, and the United Nations Security Council was debating whether that was genocide. And then after the genocide, all these big powers rushed into Rwanda with water and food and so on to give people already dead. So I think the UN system must take a fresh look at itself. I think the 5 members of the Security Council must take a fresh look at themselves and look at the events that have happened in the world where there's been destruction, where there's been war. What has been the role of these superpowers, who are the bedrock of the UN system as a bedrock of international law. It's very difficult for me to go further than this, but I think it shows you the difficulties we have, especially those of us out there in the developing world.
Can I ask you, we have a time clock that is counting down to when we explode or taken away. And I was going to ask Dominic and Dalia for a very brief comment in the time we have left.
I find myself in agreement with what's just been said, and it's just about the reality of power. The UN was set up with its power structure, including the permanent members of the Security Council and the veto system, as a reflection of how power was distributed in 1945. There are arguments for changing the composition, but that's where we are. The reality is you often can't get a UN resolution on something which ought to be resolved upon because a power exercises veto. Sometimes, take Kosovo, for example, the UK and others intervened against what was effectively an attempted genocide against Kosovar Muslims by the Serbs under the doctrine of humanitarian necessity because it bypassed the need to go and have any discussion at the United Nations, but it was done because we had the power to do it. If it had been the Uyghurs in China, we don't have the power. So I think one has to, I'm afraid, get to some bottom line, rather unpleasant truths about the way in which the world operates. But that's not a reason why we should despair of the international rules-based system, because when you compare where we are to where we were 150 or 200 years ago, actually we are in a better place. And I think we should never forget that. We should continue trying to build on what has been achieved so far and be optimistic, even when there appear to be setbacks.
So I know in our conversations over the past couple of weeks, you think I'm pessimistic. So here, let me try to be optimistic for a change. The principle of national interest versus human interest puts them as 2 sides of the same coin. But perhaps we're moving in a direction that we're starting to see that the protection of human interest is in the national interest. And through this rules-based system, we're seeing these indicators that we've studied for a very long time on war and mitigators of war are beginning to have countries redefine their national interest to include the protection of the human interest of others. And if we continue to move in that norm change, there's a possibility that I will continue to be optimistic and that the peaceful resolutions to conflict is possible because it's in everyone's interest to do so.
Well, thank you very much. I'm very glad. It's very easy in the current situation to get very, very depressed. But I hope that by discussing, by there being unanimity about the general approach, unanimity basically about the major problem to getting there, nonetheless, we are much better off than we were. And I hope we leave this panel, at least, with a feeling of optimism rather than a feeling of pessimism, which is so easy to arrive at. So may I, on your behalf, thank our panelists who've come from such a diverse background, but yet are in complete agreement. Thank you very, very much.
Thank you.